Chapter 18. Let's take a look at the kind of the credit system, I guess you would say, and some of the things that go on there. Hopefully there's some stuff here maybe that you'll get a little practical advice, normal stuff that kind of happens day to day. So we talk about the legal fence of property, right? Texas possession, yada da da da. Got to have limits, right? So can't injure other people, et cetera, et cetera. So we'll talk about consumer protections, both in credit, I guess, and there's other protections that are out there as well. Understand how the law defines a consumer, right? Federal Trade Commission's Consumer Protection Mission. And we can't have unfair or deceptive trade practices. Evaluate the provisions of various consumer and financial protection laws, certainly. So who is a consumer? By definition, is a natural person. So in this case, we're not protecting corporations, those types of things, right? But it can be somebody that incurs debt for personal, family, or household purposes. Consumer protection primarily is through the Federal Trade Commission, although I guess on the credit side, which we're going to be talking about, is that's changed. It's probably now with the new Consumer Financial Protection Board. I think that's the name of it, or the right order of the letters. I think we get to that a little bit later. But that may be more in line as a protector, supposedly now, of consumer protection. So regulations, right, are in place through the FTC that prohibit unfair, deceptive acts or practices in commerce. They give advisory opinions, certainly, and there's industry guides and there's trade regulation rules. Nothing terribly exciting there, right? There can be, of course, civil fines. Corrective advertising can be ordered. They can rescind a product, okay, or an action. Consumer refunds obviously can take place, and there has to be, public notice required. And these are cases, you'll see these sometimes with, bad advertising, where they're advertising a product that may not may not end up performing as well as the advertisement, right? And that can create some issues, right? So we want to prohibit deceptive trade practices, right? So what is deception? Who's a reasonable consumer? Okay, so it's not necessarily the very bottom consumer, right? It's a reasonable one. There's express claims, and then there's implied claims, right? Misimpressions, materiality, et cetera, et cetera. There should be sufficient evidence to support the ad, right? And you must have, I guess if you're a company, then you better have that proof in order to do that. So the FTC today, right, and we may see, changes here, right? The mission varies according to orientation of the president and the Congress. So obviously we're going to maybe go through a change here. It's interesting that most people believe that the new Trump administration will be more of a hands-off, and yet in the campaign and towards the end of the campaign, he very loudly spoke out that he was opposed to the AT&T Time Warner merger, which would be contrary to what most people are kind of believing. So it'd be interesting to see, how some of those things move forward. So FTC has great discretion, right, determining what's deceptive or unfair, and they can make new rules and et cetera, right, depending on those things. So they also administer other acts, the Equal Credit Opportunity Act, the Fair Credit Reporting Act, and the Truth in Lending Act, each of which, of course, when I was in banking, each of which were really important, to things that we did, obviously, on a very, very much on a daily basis. So Equal Credit Opportunity Act, right? It's to prevent discrimination in credit. And we'll see that a lot of these same things are the things that we talked about, or will talk about, I guess, in employment, right? We can't discriminate based on sex, marital status, race, color, age, religion, national origin, receipt of welfare, or many other things, actually, in terms of credit administration, right? Or credit delivery. And there's penalties, can be. Actual damages are compensatory, right? If you fail to give somebody a loan, maybe it cost harm, right? Punitive damages can be up to a 10,000 fine per incidence, right? Attorney's fees, legal costs, etc. And these aren't just for banks. We oftentimes think about banks, but it's not just for banks. There's lots of places that extend credit. Be it the local furniture store, whatever the case may be, and some of these would apply for all of those as well. So the Fair Credit Reporting Act, right? So what happens if you're denied credit, insurance, employment, any of those things due to a bad credit rating? And look at that, insurance or employment. Wow, what can happen there? So the truth is that the first thing you can do, they have to notify you why they denied you for whatever. You have a right to then obtain a copy of that report that they received, upon which they based their decision. Okay, you have a right to get your credit report anyways, but in this case, you have a right to that particular one on which they based their decision, and it's worth asking for that. Okay, very much worth asking for that. So, who uses? I think we talk about that. Let's see. Yeah, when you're denied credit, you have to be told the name of the credit of the agency, right? And you get a right to the information, and you have a right to correct, right? Or you can also make a statement as to your version of what might have happened. And we saw that a time or two where I would see a consumer statement actually in somebody's credit report. Not very often. Most people honestly didn't spend as much time worrying about their credit as they probably should have. I hope we come back to the credit. We'll see. So, Truth in Lending Act, right? To avoid, I was going to say, uniformed use of credit. How about uninformed use of credit? So, the truth in lending, we always call it Reg Z. So, Reg Z in banking, anyhow, is what applied to us. The Simplification Act. And what it did was it required the disclosures of lending loan information so that consumers could make an apples-to-apples comparison. Sounds easier than what the actual result is, but it did simplify that. Not necessarily simplified it for the financial, like the banks and whatnot, but it simplified it from a consumer standpoint where you could make more of an apples-to-apples comparison. There's still ways they can hide things and do those types of things. And of course, as with many, there can be civil and criminal penalties, but assures meaningful disclosure of credit terms. So finance charges and APRs and how those get disclosed, again, so that you can make more of an apples-to-apples type of a comparison. So any loan that you enter into, there should be something on there that's called a Fed box, okay, and it probably circled, or not circled, but outlined in bold, and within that it should have these types of things: all your finance charges, your total finance charge that you'd expect to pay, and the APR, or the annual percentage rate as calculated, taking into consideration all the finance charges. Transactions, right? Lenders in business of extending credit, so of course banks, but also again any of those places, like your local furniture store, appliance store, something like that might extend credit. They're required to do some similar things. So debtor's a natural person, not a corporation. So we didn't and don't have to make the same types of disclosures for folks that were companies or businesses. Okay, and although this is corporations, it extended to even small businesses and LLCs, LLPs, those types of things. Finance charge, so it covers people to whom a finance charge may be imposed. Credit is obtained for personal or family or household. This says agriculture, but I'm going to tell you that agriculture falls into this small business category. At least it did for us. We did not have the same disclosure requirements for agricultural entities, and most of our entities too, a lot of them were corporations or LLCs and whatnot. And so that may have been the reason why, but we certainly didn't have to make the same types of disclosures to agricultural entities. Now, we made, and it just kind of made sense. I mean, typically our disclosures were pretty much the same because you used the same software and everything when you were creating your loan documents. There's a few differences in terms of things that we had to do and whatnot. Debt collection. What happens there? Fair Debt Collection Practices Act. Covers consumer debt collection, protects against certain debt collection agency techniques. An agency must be in primary business of consumer debt collection for others. So this covers collection agencies, right? And what they can do and what they can't do. Okay, and there are certain restrictions on those. I'm going to give you one example. They can't call after like 9 o'clock at night or 8 o'clock. I'm not even sure what the time is. We couldn't as a bank. We had hours that our phone calls were limited. Too bad. I once asked my buddy who owned a bar, I said, do you have problems collecting, bad checks when they get written to you? And he said, and this, of course, this was back when everybody had landlines and whatnot. And he said, no, not so much. He says, what I do is when I come down to close the bar up, or when my people are closing the bar up, and there's some bad checks that were written that we're hanging on to, he says, I just make sure they call them there at 3 in the morning, 2:30 or whatever, 2:30 in the morning, and ask them about the bad check. He says, and the first or second time you call them at that time in the morning, they end up coming in and taking care of the check. So debtor must give written notification to an agency to stop, and it doesn't mean that they stop collecting, but you can tell a debt collection agency to stop certain actions. You can write to them and say, you can't call me at work. Okay, you can write to them and say, you can't call me at these hours. You can write to them and say, you can't do these types of things, right? Okay, and that's what's important. You can't stop them from trying to collect the debt. They still have every right to do that. State laws, I don't know, again, that Montana has a lot of laws that are outside of the normal federal laws when it comes to debt collection. So the Consumer Financial Protection Act created the Consumer Financial Protection Board. That's what I was trying to say earlier, right? And it administers these things. Okay, so again, I think this is a little bit outside the FTC now, and maybe some of these fell under the auspices of that. And I guess I haven't looked at the structure. This could be under the FTC, but I don't know. Okay, it administers those things we talked about earlier. It says the authority overlaps, so that makes me think that it was created separately from the FTC, that it is its own board and operates independently but overlaps somewhat the FTC. What do we do if there's a bankruptcy, when there's an inability to pay? There's a filing of a petition. Most people do that voluntarily. Okay, most people will do that voluntarily. I never in my years saw one that was involuntary. I saw creditors that would push debtors hard enough that eventually they would file, but I don't ever recall creditors actually forcing going to the court and saying we want this person to be declared bankrupt. We didn't, not that I remember anyhow. Creditor must be owed at least $2,300 in order to do that involuntary. So a couple different types of bankruptcy, and there's more besides these two, but there's Chapter 7, which is liquidation of assets, meaning basically all the assets of the debtor are put into the hands of a trustee who then administers that and sells off the property, whatever, in order to try to satisfy the creditors. And Chapter 13 is an adjustment of debts, it's called. We also call this a wage earners plan. Okay, the 2005 amendment, it forces the median earners to adjust, above median earners to adjust rather than to liquidate. And what that's saying is, and I'll tell you what happened. What was happening is you'd get people that were making a lot of money, especially doctors and lawyers, hate to pick on them, but they'd come out, they might have a lot of student loans, different things like that. They'd also run up credit cards. They just get credit cards, and companies were willing to give it to them, and they'd run up debts and be credit cards or other consumer unsecured debts, so we're not talking about car loans or house loans, and then they'd go file a Chapter 7 bankruptcy. Well, that would eliminate a lot of those unsecured debts. Didn't eliminate the secured ones. We'll talk a little bit about that, but it kind of gave them a little bit of a clean slate. Yeah, they still had to pay their student loans because those don't go away, and if they wanted to stay in their house and keep their car, they still had to pay those loans, but they could get rid of some of those unsecured debts, and folks were kind of taking advantage of that. And what this law did in 2005 is it said, well, the bankruptcy judge has a right to take a look at these folks, and if they're making decent funds, decent money, we can make them keep paying, a certain amount of money on those other like credit card debts and whatnot. We'll put that in the hands of the trustee, and we'll send monthly payments if that's how they get paid, onto those creditors. So, trustee is elected by the creditors to present. Yeah, generally speaking, I saw the bankruptcy judge. I suppose the creditors kind of nominated, and the bankruptcy judge would appoint. Creditor priority classes, so they must satisfy debt by classes. And what's that mean? Well, the classes are secured or unsecured, basically. Okay, maybe a bit of an oversimplification because you may have priority liens and those types of things, but that's and there's rules in bankruptcy about which of those. Obviously, unsecured creditors take a back seat to secured creditors, generally speaking. Discharge a further obligation by debtor to creditor. It can happen, and again, it says certain debts cannot be discharged, and I think we'll talk about a few examples of those. And those that go to Chapter 13, are typically not discharged, right? They're set up for payments then. So goals, provide a fresh start, and believe it or not, even as a banker and as somebody who has fought people in bankruptcy a decent amount, it's a law that I completely agree with. We wouldn't have people starting businesses, taking entrepreneurial chances and those types of things if we didn't have bankruptcy laws that kind of is a backstop in case they fail and when they fail, and that happens, unfortunately. And you can have obnoxious creditors that can create problems for small businesses that have used Chapter 11 to get reorganized in small or big businesses, okay, etc. And so there's good things. Now, does it get abused? Yeah, and hopefully those abuses get taken care of over time, and I think they get handled pretty well. The judges do a reasonably good job. Although I, would argue certainly even some of the cases that we were involved in where I thought the judges' decisions weren't appropriate, but it happens. You move on. So, Chapter 7 again is a liquidation. We've talked about that. And Chapter 13 is a wage earner's plan. And judges have that. Again, you might file a Chapter 7, but a judge has the discretion to say, sorry, you're making money. It's going Chapter 13. You're going to have to make payments, even on your unsecured debts, and away you go. Chapter 11 is business reorganization. So it's much like the wage earner's plan. Here, a company goes into a Chapter 11 bankruptcy, and they present a plan to the judge, and the judge works with the creditors and the trustees, and they try to figure out how they can make it work. And when they do, then the business is said to be reorganized. There's a few big ones that you and I are familiar with that have been through Chapter 11 bankruptcy. Northwestern Energy, which supplies the energy for Havard, natural gas and electricity, went through Chapter 11, not that long ago, in the last 10 years anyhow. How about Kmart? Yeah, Kmart went through a Chapter 11 bankruptcy, and they might again here. Kmart / Sears now, they might go through another bankruptcy in the next few years. Who knows? It's possible. Yeah, we saw this gradual increase, and then that big drop, right? Peak here before the law changed in 2005 that we talked about earlier, and then of course there's a big drop off and inched up again, and of course during the recession it inched up quite a bit. So in Chapter 7, right, debtors' assets are placed into the hands of the trustee. The trustee liquidates that and pays the creditors, etc., right? And usually creditors, and I can attest to that, only receive a fraction of what they're owed. We typically, if you were lucky, you might get 10 cents on the dollar of what you were owed. Okay. And that differed. There were probably times when we did better than that, and there were certainly times when we did worse than that. There's no question about that. So is that all assets? Not necessarily. Again, in a Chapter 7, you get to exempt certain things. For example, your vehicle that you need, to get back and forth to work. Now, does that mean that the debt goes away and you keep the vehicle? No. Everybody go out and get a Range Rover, right? A $80,000 Range Rover, and take out a loan and then file bankruptcy, right? No, it doesn't mean that. It means that you either are going to show the court that you can continue to pay for that Range Rover, or you're going to give that back to the bank, and you'll have to go buy something a little less expensive, bank or the whoever financed it, right? Okay. Non-dischargeable debts. So if you're in bankruptcy, things that the courts just say, hey, you can't get out of paying. Paternity. Okay, so child support. I guess paternity and child support's same. Alimony, maintenance, basically the same. Okay, you can't get out of those. Many more. Student loans are non-dischargeable. Tax debts are not dischargeable. I'm trying to think of some other ones. Those are probably the main ones there. So in addition to those that are on there, think taxes. Taxes are definitely non-dischargeable. And student loans are absolutely not dischargeable in bankruptcy. The things that you can exempt, and again, just because you exempt them doesn't mean that you get to quit paying for them. But your residence, your vehicle, household goods, yeah, and those. I guess if you borrowed money from the furniture store, for your 64-inch TV or something, yeah, you'd either have to give it back or keep making payments on it. Jewelry, tools, any of those things, but they don't, like your tools, I mean, they're not going to force you to sell your tools, okay, in order to pay some debts. If it's tools that you need that are basic household items, tools, your silverware, those types of things as well, right? They're not going to force you to sell those things in order to satisfy creditors. Now, if you've got if you're just a shade tree mechanic, or you're just like a person like me that maybe you got way too many tools, you could be way too many collections of things. It's possible that they could tell you that you're going to have to sell some of those things, right? Life insurance, right? You get to keep health aids, of course. Social Security benefits, that means that they can't be garnished like you can somebody's wages or other things or other income, and some other miscellaneous. But again, do you get to quit paying for those things? No, just because you exempt them. If you want to keep them, you'll have to keep paying for them. So I got there. Oh, I think we had that one earlier. So in 13, right, debtor's assets aren't liquidated. Now, some can be. And the judge may order that some assets may be again, if you have that Range Rover and you're paying $1,000 a month for it, the judge may say, you know what, you don't need a Range Rover, you go get a Toyota, okay, and instead of, pay $300 a month, and that way there's $700 a month we can free up and send to the unsecured creditors, the credit card people and whatnot. So you can it can be kind of a combination. They're not necessarily mutually exclusive, right? And again, the debtor's finances are placed under court control. However, it was not uncommon when we saw these, and in a decent number of them, there's something called DIP, or debtor in possession, meaning the debtor was actually appointed as the trustee. God, how could that be? Somebody that's not taking care of their finances and whatnot. Oftentimes when I saw Chapter 13s, it wasn't as bad a thing as what you might expect. I remember one customer in particular, and his wife had suffered with cancer for years and years and years, and he was a good guy, always paid his debts to us, and was doing his best to pay the debts that he had at the hospital, but they were just too big. They were just insurmountable. They were too big, and so he had to file a Chapter 13, and they set up a plan where X amount out of his pay went to pay the hospital every month still, and he kept the rest and had to survive on that. And it was a debtor in possession. He didn't have to send his money to a trustee. That would have just created another expense, and he was very good about it. And so that was probably as common as what I had seen back then. Of course, I was, that was before the 2005 change in the bankruptcy laws. So you're probably seeing more of that in terms of those credit cards and other things. But what I saw with the Chapter 13s, typically when I saw those, they were oftentimes medically related. Okay, and so people again, and another reason why I don't mind the bankruptcy laws, because these were people who were honest and good, but they, life threw them a curve, and they were still doing their best to try to overcome some of those things. So, Chapter 11, the business continues to operate, but it becomes under the court's control. and they do payment schedules, and it could be voluntary or involuntary. And what we often saw was folks that just ended up having a um, um, whatever the case may be, they had payments or balloon payments or large payments that they just couldn't handle on an immediate basis, and so they need to restructure those payments over time, and that just wasn't that unusual. Okay, there's a lot of debts that are structured with balloon payments, or we'd also see companies that would come towards the end of the amortization, their cash flows would be adversely affected because they still had to make the same payments, but they didn't get the same tax benefit. Long story there, good finance story. But anyhow, it made sense then for them to oftentimes just reorganize. And if the creditors wouldn't do that voluntarily, then the business would go to the bankruptcy court and do it under a Chapter 11. So additional, right? Fair Credit Billing Act, Electronic Funds Transfers, Consumer Product Safety Act. I don't know that we get into a ton of these, and there are state consumer protection laws as well. Privacy. Now this has gotten to be a big deal. If you're anything like me, you get in the mail probably once a month at least some statement from your bank or your insurance company or whomever it might be that says, here's our privacy policy, dealing with your information. We're not going to give out your info, et cetera, et cetera, et cetera. So and that's why some of these companies that get hacked, obviously they get in trouble because that information gets out beyond their control, I guess you would say. So we had to bring some new regulations in to cover things like the internet, right? And children's online privacy, right? Can't collect data regarding children without parental. The EU has banned cookies, okay, unless there's consent, and I see that more and more here. Occasionally you pull up a site or something, and it'll say, "Hey, we want to have cookies and tracking and la da da," and vote yes or no type of thing. And so, how about that? Remember, employers may monitor your email and other computer use at work. In most cases, voicemail and telephone usage is still protected. So what's that mean? Okay, your email, that you use at work is not yours. Okay, this kind of always amazed me when it came to a certain former presidential candidate. But in fact, it's not just not yours, but your employer is actually required to keep records of your emails. Okay, in case something happens that they have to go back and figure some things out. Okay, and boom. So your communication that you're doing, over the internet from your work is totally subject to lack of privacy, I guess you would say. They can and will look at it, and they should, right? In most cases, voicemail and telephone usage is still protected. What's that mean? Here's the key, though. Your employer can restrict your usage of telephone for personal reasons. And telephone's getting to be less and less of an issue, but because people have their own cell phones, right? And if they're going to call somebody, they probably use their cell phone. But your employer can put limits on that too, right? Your employer can say, hey, well, you're working, you're on my time. I don't want you getting your cell phone out and texting and calling people, okay? And I imagine a lot of companies probably develop policies regarding that, and it's I didn't work in a bank in that era, but I imagine that in today's era, you want your people, your employees, to be able to communicate though with the customers in the way the customers want. Sometimes that is the texting and those types of things. So it's probably hard to put some limitations on it. Different certainly than it was 20, 30 years ago, where we did put those kinds of limitations on people's use of the internet, et cetera, et cetera. And obviously we could track those things. So I want to check. Debtor creditor, yep. So, and I think this was something that you guys had earlier, right? Creditor's right to collect judgment, right? Liens, mechanics, artisans' liens. So, and these end up with some priority, right? Mechanics liens end up with priority over a bank lien. So even though you go to the bank and you purchase a vehicle and finance it through the bank, you take it in to get it fixed, the mechanic gets to get paid first because he made your car whole, right? And so he can put a lien on there if you don't pay him or her, I'm sorry, and he can put a lien on there and make sure that he gets paid. And artisans would be craftsmen, contractors, those types of things. Adjusters are horse keepers, this originally, but that would be ag. If you say you take care of somebody's critters, you're renting them pasture, those types of things is what that amounts to. And ways that you can collect. You can obviously get a judgment on people if they don't pay you, and then you have a right to attach property. You do have to get a writ of execution. This becomes difficult, and typically what we did was we would execute, if we could, against people's bank accounts. So if somebody didn't pay you and you knew they had a bank account over at Wells Fargo, you'd go to the court, get a writ of execution, you'd go over to Wells Fargo and have that served, and then up to the amount you were owed, if they had any money in their account, you would be entitled to that. Okay? And that would obviously cause problems for people because all of a sudden that money would leave their account, but maybe they still had some checks and stuff outstanding, and so it really created problems for people. But it's kind of their fault, they got into that situation to begin with. So but that's a writ of execution. You could do it against other property. I don't recall ever executing against other property. We would, don't get me wrong, we would repossess property that we actually had a lien in, but this is stuff that you could get. You could obtain a lien based on a judgment. It was difficult, long time process, but we would execute against bank accounts. Garnishment, we did this often, was taking a share of the person's wage. Generally speaking, once we would start to garnish a person's wage, it'd get them in the door and they'd set up a payment plan. And the reason for that is because our minimum cost for each garnishment was, back then it was like $50. Okay, and we had to do that, go through that same process every single time we wanted to garnish. You couldn't set up a garnishment that would, take it out of that person's wage for the next 20 weeks or whatever. It was every single time. And so you'd garnish their wage, you'd get $100, and 50 of that would go to pay the fee that you just incurred, and then the other 50 would apply to the account, and it might take forever, right? And so people would come in. And then obviously you can foreclose on real property, you foreclose, or you can repossess personal property. Debtor's rights. You have a right to a homestead exemption. And again, what this allows you to do, and I see people file this, you go back to those same people that have medical issues, that's what I typically would see if people would file a homestead exemption. And that just means that it would protect your house to a certain extent from a hospital or somebody getting an attachment, and then foreclosing on your home. It would protect it from those types of actions. It doesn't protect it from, purchase money security interest, basically, where, a bank that finances the purchase of or refinance of your home, you don't get any extra protections for those types of things. Okay, and you can exempt, and again, this is in bankruptcy, and we talked about that, furniture, tools, vehicles. So credit scoring. It's gaining widespread use, okay? And lenders, obviously, they've always used it, but insurers are using that more and more. Can they charge you different based on your credit score for car insurance? The answer is yeah. They prove that people with better credit scores are less risky, and so they can change their rates. Interesting, right? Landlords, yeah. Do I do that as a landlord? Yes. Okay, yes, I've done that in the past. It's become more difficult for me to get a credit report, and so but I still rely on credit. I check people's credit. There's other ways that I can do a little bit of that, okay, and many others. Okay? If they have a legitimate reason to access that information, they can. Okay. I think, this is me, this is kind of my opinion here, but it's creating a society of haves and have-nots in regards to credit. I think this is unfortunate a little bit, but it's kind of where we're at. Many lenders, at least privately, speak of the 720 cliff, and when I was in banking, it was the 620 cliff. And why has it changed? Well, I'll give you again my opinion, but what that means, that's a credit score that's done by Fair Isaac, it's called, and because they're kind of leaders in this. And you can look at that credit score, and a lot of lenders have started using that, have been using that, I should say, for decades now, to make those types of credit decisions. It makes it relatively simple and fast. Either your score's 720 or it's not. If your score's 800, you get a better interest rate. If it's 720, you get the base rate, and that's that. Okay, and applicants that fall below that may have restricted access to credit. Okay, and it used to be the 620 cliff. Why is it 720 cliff? I would argue that a lot of the new regulations, the Franken-Dodd and those other regulations that have come along, have made it more and more onerous for banks to extend credit, and so we'll just restrict it then to people that are better credit risks. If we're going to take the time and effort to extend credit, we want to make darn sure, more so now than ever, that we're going to get paid back, and so we'll restrict it to the better credit. And so completely understandable, why they would do that. Now, unfortunately, I think that it has restricted access to credit to people that are a little lower on the credit score, and maybe the socioeconomic status too. But again, that's kind of my opinion. So credit reporting. Credit reporting is important for you. This is something you guys need to get up on, right? It contains, right, trade lines. That means things that you would, if you've got an account maybe at ProBuild or Haver Home and Hardware, those types of things, they can certainly report. Loan histories that you might have with banks or other financial institutions. Collections, that's if you've been turned over, if you haven't paid somebody. I use collections sometimes as a landlord, where people don't pay me, they move. I don't want to go through all the effort of trying to collect that debt myself, so I'll turn it over to a collection agency, and that will show up then on that person's credit report. Honestly, that's one of the reasons I turn it over, because then I know it's going to show up on their credit report. It's vicious, but that sometimes incentivizes people to go ahead and give you a call and try to make those payments. So legal actions, some of those can show up on your credit report. Usually it's the legal actions that are involving credit. If you don't pay child support is one, for example. Okay, some other information, name, address, phone number, all those things, right? 3 main companies that provide credit reports in the U.S., and that's TransUnion, Experian, and Equifax. Yes, that'll be on the test. Okay, know all 3 of those. Okay, that's important. They provide the credit report. So if you go to the bank and you apply for a loan, then the bank, our bank used Equifax, but it doesn't matter. It could have been one of the other 2. I think we found that Equifax was a little more regional for us, kind of tended to have more information from this area. It may not be true now, with the proliferation of information with the internet and stuff, maybe not as big a deal. The law now requires that you'll have free access, right, to your own credit report, and you get that at least once per year from each of those agencies if you want to. Okay, should you get your annual credit report? I usually get mine in the spring, about the time I'm doing this class in the spring and I'm talking about it. I'll go take a look at mine at annualcreditreport.com. Okay, this is the site. This will be on the test. Okay, www.annualcreditreport.com. You can go to. You gotta kind of fight your way through a couple little deals. I mean, they have a right to try to sell you your credit score and a few things like that. So you got to kind of work your way through that to get to the actual free credit report. But they're obligated to provide you a free credit report, according to our U.S. government. There are private places. People have told me that Credit Karma is okay. I've seen them advertise a lot, but they're going to be even more vigorous in their sales efforts probably than if you go right through Annual Credit Report. This one's a little bit premature, but what's left? Sorry. There's chapter 18 for you.